and accountability of the Judicial Service Commission takes great exception to this development and demands that political and other leaders cease forthwith from this ignoble conduct that interferes with the work of the officers charged with the administration of justice. The emerging culture of public lynching of judges and judicial officers by the political class is a vile affront to the rule of law and must be fiercely resisted. This is particularly so when the tone and the regularity of the condemnations transgress the ordinary boundary of disagreement and debate on judicial pronouncements and large alarmingly in the direction of intimidation and blackmail. Indeed, the chronology of attacks is quite worrying. On December 22nd, 2016, Honorable Aden Duale accused Judge Odunga of playing tribal politics and being partisan. This was in regard to an application by the opposition on proposed amendments before Parliament. In May 2017, NASA leaders Raila Odinga and Kalonzo Musyoka said their supporters would take to the streets in event the Court of Appeal ruled in favor of IEBC on the question over who should declare the final results of the presidential poll. On July 9th, 2017, President Uhuru accused the judiciary of working with the opposition when the High Court ruled that IEBC must re-advertise tender for printing of presidential ballot papers. On 10th of July 2017, President Uhuru and Deputy President Ruto insisted that judges are working with the opposition to postpone elections. On July 11, 2017, Cabinet Secretary Mwangi Kiunjuri and Kinango MP Gonzi Rai accused the Chief Justice of and I quote, failing to conduct due diligence in appointing Justice Odunga to sit in the bench of the Algural case. We wish to state that the Judicial Service Commission and the Judiciary will not cower to these intimidating tactics. Judges and judicial officers have no opportunity to defend themselves, and the Judicial Service Commission wishes to assure them and the public at large that it will remain steadfast in defending the judges and the institution from unwarranted attacks. The Constitution provides that judicial authority derives from the people, and the decisions that are guided by the law and the evidence presented are alive to this fact. We wish to remind the politicians that our judicial system incorporates sufficient avenues for recourse should litigants be dissatisfied with the decisions made by our courts. The most obvious one is Appellate Avenue, which the political leaders have themselves used extensively in the past, allowing litigants to choose their judges would be tantamount to abdicating from a cardinal principle of judicial and decisional independence that we hold very dear. The Judicial Service Commission wishes to further state that we will always be at the forefront of defending the cardinal principle of decisional independence of judges, and that we will at no time direct any judicial officer on how to decide on the cases before them. Neither will we ask them to recuse themselves from the cases filed before them. Recusal is a matter of fact and law, and the Chief Justice cannot direct a judge or disqualify him or her from a matter. The rules of recusal are clear and are a matter of personal prerogative, and we leave it to individual judges to decide whether their relationships and associations outside the courtrooms bear the risk of hindering them from delivering justice. Finally, let the public have no doubt whatsoever that the judiciary is prepared to handle all election-related disputes at all levels, swiftly and fairly, and without fear or favor. Signed by the Chief Justice on behalf of the Judicial Service Commission.